they offer me 40 hours of community service. Is that still on the table?
Okay.
If I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
That
Yeah,
may
it says automobile, horse, drawn wagon, or carriage.
Okay.
So an
that's-
automobile is not necessarily a car if it's a household good.
but
I
all
mean,
of those
an
things are not true.
automobile was actually created before a driver's license was ever created.
Part 1. All right, today's hearing is one for the books. We've got a so-called sovereign citizen standing before the court, insisting that he wasn't driving a car, but merely traveling. It's the classic argument that shows up in these cases, and of course, it doesn't hold up under the law. From the moment he starts speaking, he just keeps going, tossing out legal buzzwords and half-understood statutes, as if repetition will somehow make them valid. What really stands out, though, is the judge's approach. She listens longer than most would, and honestly, I'm torn on whether that patience was helpful or would just let things drag on. Some people might say she should have cut him off much sooner, while others might see it as her giving him every chance to explain himself. Either way, this is a fascinating example of how courts handle arguments that don't have any legal foundation. Let's watch how it unfolds.
You hear me?
Yes,
Okay.
I hear you.
So you're before the court on 2019 CR 04954 for driving on a suspended or revoked license, no license, failure to display license, or failure to have license on person. I'm not sure, it cuts off, and no tag or expired or invalid tag. So that's on the first case. On the case from 2020 03114, you have a suspended or revoked license. You're represented by Lister and Holt on one of the cases, but not on the other. Did you want Lister and Holt to represent you, or did you want to represent yourself?
I'll represent myself.
On both cases?
Yes, ma'am. I have a quick question as far as locker term when it comes to driver's license.
Okay.
Okay, you're only allowed to have one driver's license, and I have an Alabama driver's license. So when I get pulled over, I actually showed them my Alabama driver's license, and it's current. It's the most current, and so they make a determination if they should go off the Georgia driver's license or the Alabama driver's license. And when I present the Alabama driver's license, they let me go because my Alabama license is valid. And you're only allowed to have one. And I had Alabama license first. So my
I believe
Georgia
this sounds
driver's
like a
license,
not guilty.
Okay. So, Mr. Resto, what Mr. Taylor is saying is this is something that you could prove at trial. If you present that information at trial, then that means you want to go to trial instead of taking a plea. I don't know what the recommendation is, and I don't know.
Well, the recommendation was, I think I've been dealing with this case for an awful long time now. So
Yeah.
I don't really want to go to trial. I just want to get it behind me. But I think that I remember the recommendation quite clear. They offered me 40 hours of community service. Is that still on the table?
Okay, no, Mr. Resto, it's more than that. So let me explain.
Part 2. Now, here's where it takes a strange turn. Instead of sticking to the matter at hand, this defendant starts negotiating with the judge like he's haggling at a street market. It's surreal to see someone treat a legal hearing like a casual deal-making session. No wonder the prosecutor and judge both struggle to hold back laughter. This behavior goes so far beyond courtroom norms that it feels almost unreal. The confidence he has while making these claims is what makes it even more baffling. Imagine being on the bench day after day, having to sort through cases where people show up with arguments like this. Most judges would likely lose patience, maybe even hold someone in contempt, yet here the exchange almost feels like a comedy skit. The prosecutor in particular shines with sharp remarks that cut through the nonsense, adding a bit of levity to an otherwise tense situation. Let's keep watching how this unusual exchange plays out.
Why I know it's more than that. So the basic fines and fees for driving on a suspended license is the first time in 5 years. If you get one, then you can enter a NOLO plea if you have a NOLO plea eligible to you, and then the fine is $500. But if you get a second one, the fine goes to $1,000. A third one, the fine goes to $1,500 and 10 days mandatory jail time. You have a second one, which means that you might be able to enter a NOLO to the first one, but then the second one is outstanding. So when you took a plea to the second one, that would definitely suspend your license. So that's what's on the table.
Okay, now if I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
Okay,
Or
I'm not sure what that is. So I have taken an oath to uphold the Constitution and to make sure that I treat people as the law would direct me to do so. So,
okay. Well, I asked this question previously when I was in your courtroom one day in regards to the right to travel under the 14th Amendment, stating that citizens do not need a permit to travel with a horse-drawn carriage, wagon, or automobile without interference by police. And I was on a public highway actually when I got pulled over.
okay, so that's not actually in the Constitution.
And
So
I don't believe
the right
automobiles
to
were
travel.
around when the 14th Amendment was ratified.
I'm sorry. Go ahead, Mr. Taylor.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified. That
Yeah,
may
it says automobile, horse-drawn wagon, or carriage.
Okay, so
An automobile is not necessarily a car if it's a household good. It's just a form of transportation. It doesn't matter if it's an automobile, horse-drawn wagon, or carriage, because it's still a form of transportation, and citizens have the right to travel without interference by police. So I don't even know how the police are even allowed to interfere with travel when I'm not using my vehicle for commerce.
Your Honor,
And it's
hold
a
on, Mr.
totally
Taylor.
private household good.
At this stage, you can feel the tension building. The sovereign citizen keeps pushing his points, and the judge still hasn't stepped in firmly to stop him. This is where many people would expect the gavel to come down hard. Judges are tasked with maintaining order, keeping cases on track, and making sure valuable court time isn't wasted on circular arguments. Yet here, the judge seems almost reluctant to pull the plug. You can see the prosecutor glancing over, silently urging the court to move forward. It's a reminder that the bench holds all the authority to set the pace, but that authority has to be used decisively. Instead, this hearing stretches out for more than 20 minutes on arguments that never had any legal ground to begin with. Some might see this as patience, others as unnecessary delay, and it raises a bigger question. How much time should courts devote to claims that are clearly without merit? That's a debate worth having. Let's see where the hearing goes from here.
Okay, so Mr. Resto, if somebody drove 100 miles an hour into the back of your vehicle and killed your a family member, would you want the police to interfere?
That's murder. I mean, that's if someone got killed.
But they're traveling. You can't interfere with somebody traveling.
No, I mean you can't. It's stating that a police just can't interfere with your traveling, like pulling you over for a traffic violation or a tag.
But you want them to interfere if somebody.
Now, if you murder somebody because
say you don't murder them. Say you just hurt them. Say you just damaged the vehicle. You don't want the police to interfere.
No. That's when it almost becomes like an accident or a crime or whatnot. So the police can. That's not really an interference. An interference with your traveling, not an interference when two citizens engage in an accident. It's interfering with you just traveling. Now, police officers, as far as public servants, they have a duty to serve to the people. So if a car accident occurs, then of course public servants, as far as ambulance, as far as firemen, they will come to the scene just as a service. But for you to just interfere in my traveling is actually a violation of the Constitution.
Well, sir, the Constitution and the cases that have come out of the constitutional jurisprudence allow cities and states and municipal organizations to regulate travel for the benefit of the citizens. So they can put reasonable regulations on travel, meaning you can have a license They can grant you the privilege of having a license to drive. They can regulate how your license is seen. If you don't have a license, or if your license is suspended, they can intervene to take your license away or your privilege to drive away. It is a crime. You can be convicted of not driving under a proper license. So the government is allowed to intervene in a lot of ways with people traveling. So I'm not sure where this information comes from, but there's a lot of stuff on the internet about traveling and the 14th Amendment and horse and buggies and even maritime law. But
I mean,
all of those
an
things are not true.
automobile was actually created before a driver's license was ever created.
And then comes perhaps the most striking claim of the day. The defendant argues that because automobiles were invented before driver's licenses existed, the government has no authority to require one. On its face, that logic completely falls apart. By that reasoning, any law passed after an invention or practice emerged would automatically be invalid, which simply isn't how legal systems work. Think about it. Taxes came long after people first earned wages, yet no one is excused from paying them. Driver's licenses, in reality, are a straightforward requirement for public safety. They confirm that a person understands traffic laws and can operate a vehicle without endangering others. The process isn't designed to punish. It's meant to protect everyone on the road. The suggestion that laws lose legitimacy just because they weren't around at the time of invention overlooks how societies adapt and update rules to meet new realities. It's a striking reminder of how far off base these arguments can go.
So people was actually their case pamphlets where people was actually operating vehicles before a driver's license ever became. That's actually, you guys are actually a conflict of interest, actually, as far as you being in cahoots with the DMV. That's a totally separate entity.
Okay,
and for
so
some
Mr.
reason,
Resto, do you want to resolve the case, because it's not
I want to resolve the
40
case.
hours
I disagree with the fine amount because it changed. I would I would make an offer like I can do $1,000, maybe 12-month probation.
Mr.
But
Resto,
$2,000, that's excessive.
Mr. Resto, we're not negotiating. Those are statutory fines, meaning they're written into the law. I can't even change them.
Can I make a counter offer to the state and say it's $1,000? Can I be?
No,
Because I did do
sir.
time in jail. If the state would see that
Well,
and count.
That's why I'm saying that you may want to speak with an attorney, because certain things that they can negotiate, I can't change the statute. I can't change what's written in it, but they can negotiate. And if the solicitor wants to give you credit for time in jail in lieu of the fine, those are things that they can do that I can't do.
Yeah. So I would ask to the district attorney, knowing that I did serve some days in jail, can you guys lower the fine and I just go ahead and end this case right now? I can do $1,000. I got $1,000 right now.
Mr. Resto, so that's a conversation that you need to have with them directly without me being present, number one. Number two, the reason I keep saying you might want to go through your attorney is because they can explain to you what is already on the table and how that may or may not change, okay?
What's on the table now?
I don't know. That's what I'm saying. I would rather you have that conversation in a breakout room with the attorney who's assigned to your case and with the state, as opposed to here in the main room. One, because I have other cases that need to be addressed, and two, because that's not information I need to hear.
Okay, is it anything I can do to get this case resolved now? Because it's been lingering on.
I'm telling you what to do, but you're not listening, Mr. Resto.
I mean, today, I want to resolve this today.
I get that you want to resolve it today, and I'm telling you what to do, but you're not listening to me. I said you can go into a breakout room with your attorney, and the attorney and you can discuss what's already on the table. And then if your attorney wishes to speak with the state to clarify anything, they can do that too. But you're not going to get it resolved by going back and forth with me, because there's stuff I cannot do. Okay.
Just tell the state that I'll take their recommendation. I'll just pay the $2,000 if they can give me 12 months to pay it off. And if I pay it off early, if my probation can be terminated, that would be great.
And then comes perhaps the most striking claim of the day. The defendant argues that because automobiles were invented before driver's licenses existed, the government has no authority to require one. On its face, that logic completely falls apart. By that reasoning, any law passed after an invention or practice emerged would automatically be invalid, which simply isn't how legal systems work. Think about it. Taxes came long after people first earned wages, yet no one is excused from paying them. Driver's licenses, in reality, are a straightforward requirement for public safety. They confirm that a person understands traffic laws and can operate a vehicle without endangering others. The process isn't designed to punish. It's meant to protect everyone on the road. The suggestion that laws lose legitimacy just because they weren't around at the time of invention overlooks how societies adapt and update rules to meet new realities. It's a striking reminder of how far off base these arguments can go.